Hello, good morning or afternoon, depending on where you may be joining us today. My name is Matt, and first off, I want to say thanks so much for joining us. We know an hour of your day is very valuable to you, so we really appreciate you spending that with us. We've got a great presentation today with a partner of ours, Universal Background Screening, and we're happy to have Alan and Jocelyn here with us today to share some great information with you. So before we start, I just want to make sure that everyone can hear me okay. And please just chime in on the questions tab of your control panel there. And as soon as I see a couple of those come in, we'll get started. Great. Okay, sounds like I'm coming through clearly. So today we are happy to present our presentation, Healthcare Pre-Employment Screening versus Ongoing Exclusion Monitoring, and we have some great guests for you today to share a lot of valuable information. If this is your first webinar, this is Michael Rosen, our co-founder of Provider Trust. He has 30 plus years in background screening and compliance in the background screening and compliance industry, and he has been our fearless leader here. He is our mainstay on our webinars here at Provider Trust. So that's Mike. And then we are happy to welcome back Dr. Alan Lasky. Alan has 20 plus years in background screening and compliance, and he worked as a clinician, as a clinical psychologist at a large organization in Los Angeles. He is joined by his colleague Jocelyn, who has worked at Universal Background Screening for 13 years, and she works specifically with their hospital and healthcare clients, and she's also an amazing chef of Italian cuisine. So we are happy to have them both. Here's just a quick map of where we are, where Universal is, and we're just happy to be here with you today. We're located in Nashville, Tennessee. Universal is headquartered in Arizona, and Alan comes from their California office. Jocelyn comes from their Arizona office. So with that, just one quick, I'll just tell you guys a couple notes before we start. This afternoon, you will receive a recording of the webinar, a copy of the slides, and your CEU certificate. Again, we really value you spending your time with us, and we're happy to present these webinars on a monthly basis for CEUs. So please continue to join us, learn with us, and grow with us as we move through the year. So a little bit about our overview of the presentation today, and then we will get started. First, Alan's going to kick us off with understanding background screening. Then we'll move into a little bit about compliance documentation, then into differences between pre-employment screening and ongoing monitoring. And then finally, we'll close out with data sources and OIG compliance. And we will in the session, if time allows, we will in the session with some Q&A. So we will move through this as quickly and thoroughly as possible. So with that, Alan, I'll go ahead and pass it to you.
Great, thank you, and thank you for joining us.
So a great place to start is actually the Fair Credit Reporting Act. And what is it? What is the Fair Credit Reporting Act? It is designed basically to protect consumers, and FCR compliance is mandatory for any employer using a third party to conduct background checks. What's important to know, it applies to all types of reports provided by a consumer reporting agency, which you also probably know is called a CRA. The Fair Credit Reporting Act is designed to do three very important things. It ensures accurate information is reported. So you want to make sure that your vendor has a sound vetting and quality assurance process in place to protect you. It should restrict and limit information that's reported. We'll dive in a little deeper about what state and federal reporting restrictions that we have in place. And it provides a dispute mechanism for consumers. So as an employer, it's your responsibility for following a strict adverse action process to make a hiring decision based on negative information. And the last thing I wanted to note is that background screening companies and CRAs should know these laws inside and out to protect you.
What we're going to do now is just really briefly go over just a couple really important points about scope of work. So, and what we mean by that is that there are different elements to a background check. We're not going to go over all of them, but there are certain things that you should really pay attention to that has ended up in litigation. Just to point out a few things about the different service items that you could add to a background check.
The first one we wanted to cover, which you're probably all familiar with, is the county criminal court search. And the majority of your criminal hits are going to be found at the county level. Federal and civil, that's completely separate court system, but the felony and misdemeanor information and the data that's found at the county level is up to date and accurate if you're pulling the information in real time. These are not database searches. And what's very important to know about the county criminal court search is that a lot of the courthouses, about 30% approximately, still require that you have to have a physical court runner inside the courthouse when they pull information. So while there's about 70% of courthouses that still allow you to pull information electronically, it's important that 30% of courts still require that physical runner. So make sure that your vendor does have those physical court runners on site to make sure you're pulling the information in real time and it's up to date and accurate. We recommend that you go back at least 7 years. These searches are federally approved and FCRA compliant, and you're at least searching by the first and last name and using secondary identifiers like date of birth and social to confirm the hits at the courthouse.
Yeah, and so as Jocelyn stated, it's important to know, and we wish that it was by the Social Security number of how court records are kept, but it's by the first and last name. So when you have a John Smith, there's going to be a lot of records that are returned, and then it's our job as a consumer reporting agency to make sure to go through those and vet them to find any false positive information, so that's not reported to the best of our ability. That's also the reason why there's a dispute mechanism that we'll talk about called adverse action in just a little bit.
It is a common misconception in our industry that when you go to the courthouse and you're pulling records, or any criminal search for that matter, that records are kept by social and date of birth, which isn't the case. They're actually kept by name. So it's extremely important that your screening firm use a name algorithm that generates name variations to pick up additional hits under other names. So by reviewing the first few letters in a person's name, you're able to catch name variants. Our example here is a good one, like a Kate, Katie, or Catherine. These are all examples of a name variations that when you go to the court, hits can be under name variations. So make sure your vendor is asking the court to pull records under those additional names. It's so important because it provides a more comprehensive search for you other than just going to the court and asking them for the exact name match, and it also reduces risk. So there are several reasons why someone could have an alias name. It could be cultural, it could be accidental, or more commonly, it could be for the purpose of hiding your identity. So it is important that you build a package asking, again, the courts to pull records under alias names, not just by the primary name.
And now what we're going to do is just talk really briefly about the information that you are allowed legally to receive back. And it's important that you speak with your provider, your screening provider, and making sure that they're not just data dumping to you information over the wall. And what we mean by that is that as on a federal level, which is what you're looking at here, there's no federal limit on how far back we can go if it's a conviction on a record. So if we find a conviction by federal law, we can go back as far back as possible. However, if it is non-conviction based, such as an arrest, we can only go back 7 years. So it's important that your screening provider is only supplying you this information. There was a class action settlement for over $700,000 to where a background screening provider provided their client over 7 years of negative information that was not conviction based. So it is important to know that information and to ask your provider to make sure that they're vetting that information. In addition, there are 9 states that we want to show you that also have restrictions, and it's important to know these, and your background screening company should, again, behind the scenes, be looking at this information of what can be reported. So for instance, in California, it's a 7-year time limit, and it's conviction-only based information that's allowed to be reported. So if you are in Nashville and your candidate is in Los Angeles, even though we don't see any Tennessee restriction here, we do see a California restriction based on where the candidate resides. So you need to use this information based on where the candidate resides and where the organization resides, where your, in a sense, where your centralization is or where the local system is. It's really, really important to follow these guidelines, and your screening firm should be doing this. We do hear of many that just provide all the information back, and it's your obligation to look through it. Also, on the last column that you see here, salary exemption, these are certain states that actually have salary amounts that if you make less than that amount, you can go back, you can only go to 7 years. If you make more than that amount, you can go back past 7 years. Your screening firm should default it to 7 years if they don't know and you haven't provided them the information on how much that person makes. So again, these are all the things behind the scenes that should be taken care of for you, but it's important to reduce risk to ask your provider if they're doing this. Also, a trend that we're seeing that's really important that many of you, I'm sure, know, if not all of you, is about asking about salary verifications. This is a huge trend, and we're seeing more and more states join the support of prohibiting the ability to ask that question anymore of how much somebody makes. Right now, just as of this year, there is a federal Ninth Circuit Court district decision coming down to make it a federal law that you are not allowed to ask that question anymore, to make sure that it's fair and just of the salaries you're providing for gender equality. In addition, as you see, there are already 2 lawsuits down on the bottom of the slide that have already happened. So there's already court law and court cases about this. So it's really important that you speak with your legal if you are still asking these questions. You see the states here that seem to be increasing all the time of new states and new municipalities that are joining of this, these new laws about not asking about the amount as someone makes. So again, just speak with your legal about this to reduce risk. So to put this all together about some of the things that some of the items we talked about and some others, when we're talking about background screening, it's important again to understand that the background screening searches are decentralized. We wish it was all in one database and you can pull it by social security number. That would make it a lot easier because information can be missed. So what you're looking at here in the graph is a top layer of counties and statewide that can be run with all jurisdictions and all alias names being best practice. And as we go down in the layers, it gives you more of a comprehensive view of who that individual is by adding a criminal database, a federal criminal database, the sex offender registry searches, a motor vehicle report, the terrorist watch list and employment credit if they can affect you financially, also primary source verifications. These are all levels and layers that are important to look at more and understand who that candidate is. And you should speak with your provider and your legal about what's best for the organization to be running, whether it's by job position or just for the organization itself to reduce risk. Now, along with that, some of you may be required to do fingerprinting, which is common within certain healthcare positions in certain states. The issue that we have with it right now, and we're very shocked about the fact still to this day that it's a requirement, because as of July 2013, the National Employment Law Project did a study, and they found that 25% of all criminal information is missing from a fingerprint, and all 50% of final disposition information is missing from a fingerprint. That has led to many cases like you see in the bottom left of a teacher charged with attempted murder who passed a fingerprint. In addition, the FBI on an NPR radio interview said that they admitted to the fact that fingerprinting is not foolproof. In addition, late last year, Virginia admitted to hundreds of thousands of records being missed in the database. So even the federal government has said best practice is, even if it's a requirement, to do a supplement with a private firm and speak with your legal about it, since again, fingerprinting is not an exact science and is missing a lot of information. Also, we understand in healthcare, working in healthcare as long as we have, we understand the urgency. It is, I mean, you need that information yesterday. That, the normal cadence we know is on a Friday, you have to have that information back because on Monday is probably orientation day. And if you don't have the background check back, they're not going to make orientation. So it's very serious. With that said, our concern with it is that still, as Jocelyn said, 30% of the courthouses are still antiquated with the way that we get information back from court runners, and some of them delay processes if there's a potential hit. With that being said, SHRM, which is the National Association, HR Association, came out with a study and found that employers are willing to sacrifice accuracy and depth for getting something faster. And the issue with that is can really be shown by the association and the case of Uber. Many of you, I'm sure, have heard, even in your local markets, that Uber has had many cases, egregious cases of violence and criminal activity from their drivers, even though they have said that they do the gold standard of background checks. And so what they do and what they admitted to is that they just do a database search only to start with, or an index file at a courthouse only, and then if information does come back, then they research it. That's really the cart before the horse, because they should be going to the statewide or the county criminal court searches that are the up-to-date and accurate information to make a decision based, again, on the other layers that we've talked about. Because of the fact of just doing a very simple database, it's ended up in over a $10 million settlement with one of their first settlements. Even Lyft was in a $500,000 settlement, and now that's case law. So that can even affect you and your organization because of the fact that there is case law out there now about doing quote-unquote bad background checks. So it is really, really crucial to come up with a policy and a procedure of, and speak with your legal about what those layers are that you're running on individuals to make sure, and to check with your background screening firm too, as a consult as well, besides your legal. We're now going to get more into screening compliance and how to reduce risk and what we see out there as a trend. Talking about this year, there are so many cases out there. These are just a few of the clippings, but the cases out there are daily with what we're seeing in background screening, which is a concern of course, for you and for us. And that's why we enjoy doing these compliance webinars and joining forces with Provider Trust to reduce risk. This is just a simple graph of, ever since I've been doing this for almost 20 years now. And when I started, there wasn't that much litigation in our industry. It was really just a whistleblower, and it would be a case once in a great while that we would see. Now we're seeing cases constantly, and the FTC, the EEOC, and even private law firms are really focused on our industry and bringing up some big, huge class actions, which we'll talk about in the next slides. The reason why we're seeing so much more litigation now is because of a few reasons. One, it's easier to find information online for a candidate that's savvy, that knows they have cases, and to make sure that process for themselves goes very clean and proper, or they're going to sue. And we'll talk about those processes in the next few slides. There's also an increase in plaintiff attorneys understanding the laws and knowing that there's big settlements. So they even have seminars and webinars for other law firms of how to sue the background screening industry and their clients. In addition, what's really frustrating for all of you, I'm sure, is that, and for us, is that there are more and more municipal laws. Years ago, there was just state laws and federal laws. Now there's municipal laws, so you can be affected by a municipal law. And in addition, the increase in settlements is the damages are anywhere from $700,000 to $3 million in class action settlements. So, this is a big ticket for a lawyer, which is why they really focus on background screening. And one of probably the most important slides to go over is this to reduce risk. This information that you're seeing here is mirrored in a lot of the laws about ban the box that are coming out, which is when you ask the question, have you ever been convicted of a felony or misdemeanor, and when you can ask that. A lot of the litigation that's coming out goes ahead and applies these guidance factors in those laws that we'll get to in just a few other slides. But this is important just to go over briefly. Whenever you have a candidate that has something back on their record, you want to review the nature and gravity of the offense. Is it substantially job related? Is the person a repeat offender? How long ago did it occur? And then you want to speak with your legal to make sure that you have a policy in place that's standardized. The reason why in 2012 all these laws started coming out, or what we can say these guidance factors, and the EEOC and the FTC became really strict, is that it was around the time of the Navy shipyard shooter and the Snowden trial. And back then, the government did an audit of those background checks and found that they were fraudulently done. And not only that, but 650,000 records were fraudulent. They were not in their files, but they were paid for. So the government really, really not only was embarrassed, but came down really hard in the background screening industry, as well as on those firms that are doing screening to make sure they're doing it proper. And so when you're doing a background check, what's important to also know too, because we get a lot of requests from healthcare systems saying, hey, will you adjudicate for us? Meaning that, we'll come up with a policy and then you apply it and you say hire, no hire, or red, yellow, green. The answer to that is that really increases risk if you're doing that right now with your screening firm. You can see some of the cases here. There are 3 cases listed that you can look up, or we can supply you information after this presentation. And so it's becoming much more litigious to have your background screening firm do the vetting of that information, because the ultimate decision based on what the federal government wants to see is by the end user, which would be the healthcare system or the client. So it really needs to be all in by the client and not the background screening company measuring and providing a negative term during that process. So speak with your legal if you are doing that, just to reduce risk in this area. And just from a high level, when we talk about standardization, which I've mentioned a few times, you always want to make sure you're standardizing your process. You're standardizing your process with your sanction screening through providing trust. You're standardizing the process through your background check by creating packages and having a policy in place, which will reduce risk of either discrimination or perceived discrimination. And also, now what I want to do is kind of change things up and talk about just 3 forms. And we're almost finished with talking about compliance here. It's really important, and this is one huge area to reduce risk by following what you see on these next few slides. The first thing is a disclosure and authorization form. This is where a lot of the litigation, as you can see down below on the bottom left, all the cases and the millions of dollars that are going on even this year, it's because their legal didn't have a proper procedure with the background screening firm in place, which then ended up in a class action. So it's very easy to follow these few points, which will reduce risk dramatically, which is number 1, use the federal and compliant language for disclosure and authorization forms that your background screening firm should provide you and your legal. Second, don't use any extraneous language, meaning don't put any ban the box language in or indemnification in. Use that exact language and don't change it. Also have the candidate sign provided before doing the background check. And a real important term is make sure it's solely of the disclosure and solely of the authorization form, meaning keep those forms separate, whether it's electronically done or on paper. Don't bleed it into an application. Don't staple it to the application. Keep them separate, because that's what the law says, and it ends up in litigation constantly because people merge those into the application as opposed to keeping them as separate forms. And the reason for that, which is why the government wants that, is to not confuse the candidate of what they're signing. The disclosure and authorization form should be separate. The next form to talk about, which is a very simple form, is the summary of rights document. So this is just a document that should be given to the candidate, and it gives them their rights in conducting a background check and if there's identity theft. It's been actually updated a few times. It was actually even revised last year, so you want to make sure you're using the most revised copy, which your background screening firm should provide you. And best practice and conservative approach would be just to give it to them up front when you're giving them the disclosure and authorization form, so you know they have their summary of rights document.
So before taking any adverse action, so if you decide you're not going to be hiring someone based on what's on a background check, there's 4 important steps that you'll follow. The first one is that you need to notify, well, actually, I'll go back. So what is it exactly? It's denying employment, it's terminating an employee based on something, or denying a promotion, transfer, or something in that category. So there's a process in place that, again, it's your employment's responsibility to follow.
And what's important to know, we get this question a lot, is anything on a report that is of a negative view that you may not hire them potentially, you have to go through this adverse action process. So it's anything, whether it's a verification, a motor vehicle report, whatever it may be, you then need to follow these next procedures that Jocelyn's speaking about.
There are 4 required steps that an employer has to follow. The first one is that you're going to notify the consumer that you may take adverse action based on the report, which is also known as a pre-adverse action letter. So you'll send that out to your candidate, and you also include a copy of their report as well as the summary of rights under the Fair Credit Reporting Act. This is something that you're also providing your candidate up front through the application process, but you need to resend it to them at this time. And then the last step is that you must provide a reasonable amount of time for the consumer to receive the notice, review the report, and then decide if they want to dispute the information or not. There's a lot of different states that have what that reasonable amount of time is. We see a trend lately that it's kind of leaning from the 5 days to the 10 days and leaving it open. But if you're unsure, you can contact Universal. We can let you know what your state requires, or you can speak to your legal and determine what your reasonable amount of time is for your state. If the candidate does not dispute within that reasonable amount of time, these are the 4 required steps that the employer must take. You'll send out the adverse action letter notice, and that's done through your screening firm, or you can send it out yourself. You must once again send a copy of the report, once again provide the summary of rights under the Fair Credit Reporting Act, and at that time you can rescind the offer officially.
And so if there is a dispute, it's important to know that the background screening firm should be handling it. If the candidate calls you, you can then file the dispute with the background screening firm, but the background screening firm needs to be involved to then take the next action, which would be to looking into the dispute and starting the process of looking and auditing that dispute. By federal law, there's a 30-day procedure. Of course, you can't wait that long because, of course, that requisition needs to be finished. So your background screening firm really should be finished with that within less than 5 business days to resolve that. And again, they should be communicating to you during that adverse action dispute process if anything comes back. That would be, you'd always want to check with them if you haven't gone through that, just to make sure that you're outlining the procedures and the support with that firm you're using. And just a few other trends that we see in background screening to cover really quickly. One of the #1 questions that we get is about ban the box. It's also in the news constantly. And in fact, now I think there's 34 states in DC, besides over 150 municipalities that have their own laws. This is where it becomes very tricky because, again, with so many laws and so many ways that it's written and so many teeth in those laws that add additional statutes, you really want to make sure you understand your specific laws to your state or your municipalities, especially if you're in multi-state. You want to speak with your legal about ban the box and what needs to happen. Most of the trend that we see in all of the 150 municipalities and 30-plus states are waiting until a conditional job offer is made to ask any question, have you ever been convicted of felony or misdemeanor, but to wait until that time. We do have 2 tools, so when you get these slides, you can click on those tools. That NELP reference is updated every 2 months for all municipalities, and it's a wonderful tool to use to look at your local municipality and what the rules are. It really is nicely laid out. In addition, social media searches we know are used constantly by organizations nationwide. It's becoming more and more popular. 70% of employers use social media. I've seen a new study that says 80%. And we understand that of why that information is readily available. The concern is that is it accurate? Is it a real page about that person? Also, we know even though it's new and the FTC allows it as a reasonable consumer reporting search, the problem still is that it may violate an EEOC guideline, ADA guideline. We know at some point it's going to rear into court based on the fact of someone violating a discriminatory act, for instance, based on what they're looking at and what they're using. So if you are using social media, you would need to be really careful and speak with your legal. For instance, is that in background screening, as we talked about California a little while ago, California is a 7-year conviction-only state. So the question that still is outstanding, because no one's tried it yet, is what if you see a picture on someone's Facebook page that's over 7 years old, when it's a state, California is a 7-year state of information, and there's something negative on it that you're using, and that at some point comes out. It will be tried in court at some point, so you have to be really careful. And what we hear from lawyers, again, this is just one solution based on some legal counsel's opinion, but you'd want to speak with your legal counsel, is that there are companies that do social media searches. Again, it's not empirical, but you also, if you're going to do it internally, have a filter person that's blind to the hiring decision and just teases out what is documented of what you want to see. So they're not influencing anything else other than just providing information that is allowed that you want to see, as opposed to everything else that you should not see. And again, a lot of the articles that we read, as you see in the bottom, to avoid a lawsuit, be objective, consistent, and document procedures, even with social media, to demonstrate information is valid predictor. So as long as you're keeping it consistent and you have documentation and a standardized process and you speak with your legal, you will really reduce risk nicely. And again, we are always around to answer any questions about this information.
All right, Alan and Jocelyn, thank you. Just like a universal background check, you're right on time, and I appreciate that. We're gonna now move into the second part of our discussion today. Again, I want to encourage you to ask any questions in the text box that we can see here. We'll address them either while they're coming in, if they're relevant to what we're talking about, or afterwards. Though we're going to now go into the difference between what Alan and Jocelyn were discussing on the pre-hire to what instead are what some obligations in addition you need to do once you have hired that individual, or you're going to learn you have contracted with a third-party vendor. So there is a big difference. So for those of you who are turning green based on all the laws and regulations that Alan and Jocelyn did a really nice job summarizing, you can let that breath out, because there are less of those rules and regulations regarding ongoing monitoring, but still some very important ones. The key here we wanted to identify for you is the difference between the laws. So as Alan and Jocelyn covered to your right, they're talking about what a pre-employment background check looks like, because it's pre-hire and all of the regulations and rules. And you see some of the items that you probably do in a typical background check, including criminal records, license verification, et cetera. But you're also going to likely have done and should be doing sort of 3/4 down on that right-hand column, an OIG exclusion search at minimum. Now that is because you can't hire in healthcare an individual who is excluded and expect to get reimbursed for that person's services in whole or in part from any federal healthcare dollar. Now that is what the law is, and why a very good and proficient background check will include. But then that becomes stale, as do a few other items in a background check, like a criminal record that could change after the day you run it. Once you've verified an education and you've graduated from the University of Michigan, you've always graduated from the University of Michigan. So what the point on the right is that there are a release that is required to do a background check and the things that have previously been discussed. Now look to the left. From the standpoint of once you have hired or contracted with a third-party vendor or individual, there's a completely different law that applies, and that actually comes both from the OIG's special advisory, which you should make yourself very familiar with, and I believe will be provided a link later on or as a follow-up. And that was guidance issued first in 1999 by the OIG about monitoring, and then recently again in 2013, I believe. Very instructive, very black and white what you can and can't do and should. But you do not need a release to conduct ongoing monitoring. I want to make that very clear. The difference between pre-hire and ongoing is substantial, based on an exception in the Affordable Care Act, Section 6501. You probably never heard of it. You don't need to bother reading it, but very clearly, you have an obligation for best practice to search for exclusions, but you do not have to have a release. And there's two reasons for it. One, there's an exception in the Fair Credit Reporting Act, because giving somebody notice that you're going to monitor them defeats the purpose when you're trying to ferret out fraud. And secondly, because the Affordable Care Act is a federal statute, there is a exception in the Fair Credit Reporting Act that if required by law, then you don't need a separate release. So you do not need a separate release to do monitoring. But why is it important to do it, and why is it not considered a consumer report? Alan and Jocelyn just educated or re-educated you on the Fair Credit Reporting Act and the term of art being that a background check is a consumer report. Why is monitoring not a consumer report? And the reason is that there is this exception in the law in both the Fair Credit Reporting Act if you're forced to do it to follow some other law, and the fact that the Affordable Care Act is that law gives you the fodder not to have a release. So the point is, liability starts, not ends, on the first day of employment. You're not done when you do a background check. You are just beginning your liability with that individual. And I do want to highlight, when we say the OIG, that is the Office of Inspector General for Health and Human Services. That is the regulatory enforcement arm of Health and Human Services, which issues through CMS, Medicare, Medicaid, or federal healthcare dollars. So they're sort of the prosecutorial police, if you will, for violations of hiring somebody or contracting when they're excluded. So now we know that when an employee walks in the door, that is the beginning of your liability for them and the reason to monitor on a monthly basis. That also includes vendors, those for whom you are contractually doing business with, and or, for example, in healthcare, it could be an audiologist that's on contract to come on to your nursing home and do audiology services twice a week. That's a vendor. So there are really identifiable chances that there's a possible risk that a new exclusion or even a disciplinary action on their license might have changed since when Universal did your background check. So what we wanted to provide to you and promised you were links to the documents. There are two here, three actually. The first one is CMS's guidelines on why you need to do a exclusion on an ongoing monthly basis. And more importantly, what the OIG, that is the enforcement arm, is telling you they're going to enforce. So this is the roadmap for you, and it's very definitively discussing what is an employee, how often you should do it, where do you need to go search, can you use a third party like Provider Trust, which you can, and also why does it apply to vendors. So it's one of the better written documents that the OIG has put out. There's also a lot of discussion in the measuring compliance effectiveness. Actually, this document was put out in collaboration with the Healthcare Compliance Association, for which you're getting continuing education hours today. We're proud to be associated with. And the OIG, and one of our employees, Donna Thiel, who's our compliance officer, was one of only about 20 selected individuals across all sectors of healthcare to go up to DC in 2017 and provide some real high-level discussion and detailed documentation on how to measure your effective compliance program. And in it are some very good recommendations, not required, but recommendations on how to do exclusion monitoring. So these are three really key resources for you if you're new or want to get brushed up on what are the laws. And is your program compliant? So again, we're talking about the difference between monitoring and a pre-hire search. While monitoring, you may find that things have changed. Again, what we find when we do find typically an exclusion, or certainly a disciplinary action associated with a licensed provider, is they get in trouble in the state of California, and they are going to be brought before or in the middle of proceedings in California with the licensing board, say they're a chiropractor. But that's not public record until they make an adjudication or decision on what to do with that license. So that's typically 6 to 9 months of a waiting period. So that provider gets smart and says, I'm moving to Tennessee. And when they do a search on me, they're going to search California, and I'm currently in good standing because that board has yet taken its action, but the provider knows they're going to in a few months. If the last time you checked that individual was when they moved to Tennessee and you don't monitor them forward, when California takes action and suspends their license and potentially excludes them, that is something you need to know about and may in fact affect whether you can use and get reimbursed that employee while they're in Tennessee. So that's what monitoring is for, is to catch the day after the background check and going forward. Healthcare employees are mobile. We don't have to tell you. And a lot of you, say, for example, where we are located in Tennessee, we're surrounded by 8 states. So people live in Tennessee and drive to Kentucky every day and go work, or they're multi-state RN licensed and they can go practice between states. And that's their job. They're actually a PRN, a traveling nurse. And so where they're licensed and where they're excluded is very relevant on an ongoing basis. The background check is very important and key to comply, but is stale the day after you hire. So where would an exclusion come from? And there are multiple places that an individual or entity can be excluded. They can be excluded by the Medicaid Fraud Control Unit at your local state level. That's for Medicaid offenses. They could also be excluded or only excluded by the OIG at the federal level. Some are picked up by both, some are not. You could separately have a licensure issue, as I described the chiropractor in California that moves while he or she is under investigation. When that happens and they lose their license, that is and can be a mandatory exclusion. So there are various ways it could result from a criminal matter involving substance abuse, and as a result, ends up becoming an exclusion. And then lastly, for those of you who are new to the game or did not know, if your provider is in default of their federal student loan, they can be excluded. There are over 2,300 people that currently are on the exclusion list. So there are a lot of places where an individual or entity can, or exclusion can start. And what do you do and where should you be searching? First, know what happens if you are liable as a result of hiring or contracting with one of them. There is no defense to it. You either have or have not hired that individual while they were in that status. And for the date and time and for however long they're in that status while working for you, and you're seeking, not even getting reimbursed, if you simply submit a claim, even if it's rejected, but you submit a claim for your provider, salary or their time services, that's all it takes for the OIG to fine you, the employer, for doing so. And it's up to $10,000 for each item claimed. So that's every patient seen every day, every item on a bill, use of services for a nurse or doctor for as many days as they're provided, times 3. That's what treble damages means. And that's because it's punitive. They don't want you doing this, and so they want to inflict a little bit more pain. You could be excluded as for various reasons. We're not going to go through a multitude of them, but they are for misdemeanor or felony reasons, typically related to substance abuse, patient abuse, or fraud and abuse. As a result of being excluded, you as the employer cannot bill or get reimbursed for their services. And in fact, the submission of the claim while they were in that status could also subject you to a False Claim Act under the Department of Justice for a separate penalty of up to $11,000 per claim. So it is extremely important that you stay current on each month with the status of all your employees and all of your vendors. So in summary, the employer, you're liable for civil fines to the OIG if you have hired or performed services alongside with somebody that is excluded or the entity that you're contracting with is. That's in the Affordable Care Act. It's black and white there. There are 2 types of exclusions we talked about: permissive, where the court or the exclusion authority has the ability, but they don't have to. That's usually for misdemeanor, exclude you. Or there are mandatory, where once the action is taken by the licensing board or the criminal court matter, and it's a felony involving substance abuse, patient abuse, or fraud, the court has no choice but to exclude. So what is the standard? Both Alan and Jocelyn spent a lot of time talking about 7 years being the standard number of years you go back on a background check and all that. Well, what is the standard for you to be liable? It's whether you knew or should have known that they were excluded. And the problem is the should have known, because these are all public records. They're public, therefore you should have known. There's not a defense for you not to know. one other thing that you need to keep in mind for those of you who say, well, I've been searching the federal list, the OIG's list, that should have everything, right? I mean, it's the federal list. Why don't they have all the states included? They do not. And they are missing up to 2/3 of the records that exist at the state level. So you need to include state exclusion searches for Medicaid in addition to the OIG. So let's talk then about what are those lists. And so on the exclusion sources only, not license and sanctions or disciplinary actions, but purely for exclusions, there are 3 places you need to search. Clearly, the OIG's federal list is the #1 place to search at minimum. Good and best practice is to include sam.gov, which was formerly the excluded party list under the government services. And we don't have time to go into it, but a search that you should also include would be SAM. And there are now 43 states since we produced this slide yesterday. And I'm going to ask you to guess which state by typing in which state it is, and Matt and I will see who is going to get it correct. As of yesterday, there were 42 states. Today, there are 43 that have a state exclusion list, meaning there are now 45 different exclusions, and we will update the slide. Can anyone, Bridget, you are on the money. Bridget's called New Hampshire, and she is right. So as of yesterday, this week, and yesterday made public, New Hampshire is the newest state. So you're wondering why they're not 50 states, right? They're all 50 have an exclusion list. Why don't they? That's a good question. There will be, but they're slowly getting their records public, and so there's about 7 now that are behind the day. Exclusion screening facts about the OIG, because this is the one you probably knew most about, thought included everything, but does not, because it doesn't have all the records from states, and was probably the included in your pre-employment background check. The OIG does not contain, for public access, Social Security numbers. You cannot search it by typing in a person's Social Security number. Like Alan and Jocelyn said, at the criminal court level, at the courthouse, you search by name and date of birth. On the OIG website, you can only search by name. And then if there is a possible record, if Matt Gaba comes up as a name possible record, or there are 3 of them, you will see all 3 with a link to the right, and you'll have to enter the Social Security number for the OIG's website to tell you if it's a match or not. So another, I guess, limitation of the OIG website, you're going to need to have the Social Security number to verify, but you can't search with it. So what is the state of exclusions? And the state, I don't mean the state of Arkansas, Tennessee, but what is the landscape of exclusions? Well, there are over 70,000, almost 72,000 federal exclusions. And as I said, not all of the state exclusions are in the OIG list, and sometimes you're excluded by one or the other, or neither, or both. And so when you look at the 3rd bullet point, you see that there are 69,000, almost 70,000 state exclusions. And we know that 2/3 of those 69,719 state exclusions are not at the OIG, so you can see the gap. Now, when you add only the healthcare related exclusions in SAM, because SAM also includes Department of Defense, Department of FDA, other agencies that are not healthcare related, you really need to worry about just those that are healthcare related. There's another 70,000. So you're looking at almost 142,000 total unique excluded individuals that are out there that you need to know if you're employing or contracting with. Now, 2 other points that are worth mentioning here on the slide. The pie graph to the right tells you the average fine based on those excluded providers and the OIG finding a company for hiring or contracting with them. So some are in the millions, some are in the 10,000s, but on average, an excluded provider will cost an employer over $126,000. Now, 100% of that $126,000 is completely avoidable if you search on a monthly basis. You will pay none of that if you monitor monthly. Lastly, the thing that we thought you would find the most interesting when you dive into the records, especially the OIG list, almost half, 43% of the exclusions stemmed from a license revocation. What is that telling you? That's telling you that you should also be doing license monitoring, because you would have caught prior to the exclusion that Matt had a problem if you're searching for license each month at the licensing board in California and you see that he lost his license for a felony drug conviction. You know that within 30 or plus days, it's going to result in a mandatory exclusion. So why not add license monitoring prior or in addition to what you're searching, so you're going to find out before they actually become excluded and be able to handle it. The problem that you also have to be aware of is the states have to report their data within 30 days of taking action, but it actually takes them 173 days. And so there's just a big gap in making sure that if you're not searching exclusions and licenses. So this is the summary of what we talked about, a slide for you to take back if you need to defend why you have a budget to do this. Thought you might find of interest the types of licenses and disciplinary actions by specialty that resulted in a license revocation. That's the federal statute 1128B4. If you have that license revocation, you're going to get excluded. Most were nurses by far, and then down based on different types of practices. That's within the OIG, how many are related to a license revocation by practice. So you see that nurses are by number large and typically have a substance abuse issue related to what their license revocation. We're not going to have time to go through the smarter monitoring slide other than to say this is an example of how by not searching between the day of hire and some future date, not searching monthly, you're going to miss multiple things that would be clues and penalties you could avoid, both licenses or exclusions. So there are a couple of takeaways, and then we'll open up to questions. Number one, if you're doing a pre-employment search, the stuff that Universal talked about at the beginning, you have to have a separate release and a separate authorization before you even start the background check. Don't do it without it. You're going to get sued and have to pay multiple fines to hungry plaintiffs lawyers if you don't do that. Two, for pre-employment, not monitoring, but pre-employment, you've got to go through the adverse action process by providing notice and an opportunity to challenge before you take action. And they did a really nice job outlining the rules there, and typically 5 days is sufficient to wait between notifying them. Whether or not they receive it is different. It's just notifying them. You have to prove you sent it, not that they received it. And then three, notice that for the healthcare background checks, each state has different laws and you need to be aware of them. When it comes to exclusion monitoring, a little bit more simple, but very important. You need to search both your employees and vendors and do it monthly. That's what the OIG says, and they're going to find, if they find it, they're going to fine you by not, when you have hired somebody or contracted with somebody who's excluded. Let me be clear, you will not be fined for not searching. They cannot fine you for not searching, but they can fine you if you are employing or contracting with an excluded provider. Secondly, that OIG federal list is not all inclusive. Don't rely on it exclusively. You've got 43 other states, the SAM and licenses to worry about. And all of this is 100% avoidable if you do this on a monthly basis. So we're going to now, Matt, open up. I think we've received questions. And you want to read which one and tell me whether that's for Universal or Provider Trust, be happy to address them.
Sure. So thanks everybody for sticking with us here. We have a few questions to run through, and then we'll let you get back to your day. Looks like the first question may be for our friends at Universal. Cora asks, or she says, Jocelyn mentioned FCRA is a requirement for background screening with specific details based on state. But is FCRA the process for all healthcare entities? Her company is under life sciences and they have contractors that are remote. So she's asking, do they have to make sure that they meet the requirements of FCRA for remote employees?
Yeah, thank you for that question. It's a good question, and the answer is yes. So the federal law, the FCRA, is under any time you're using any consumer reporting agency on any of your data, those laws and regulations have to be followed, whether it's with contractors or remote or volunteers. With a background check, right? It's an employment background check, but even we also do consumer-initiated transactions. That's just a big word for the fact of doing volunteers or doing the physician group, subcontractors, anyone that's working with the organization that you're going to screen is going to be under the federal guidelines because of the fact it has to protect those consumers. So the answer is yes. And again, we're around to answer any questions more specific if you have specific questions about that as well.
Thanks, Alan. Next question we have is from Tanya. She asks, this is for Mike here, regarding exclusions, when so much of the process is best practice or recommendations, not requirements necessarily, how does an entity show due diligence? Do things such as size or entity resources considered or factored in?
That is such a great question, Tanya. Thank you for asking it. Actually, if you look at the measuring compliance link that we gave you early on, that our compliance officer, Donna Thiel, was a part of that group, that was specifically discussed. And you're not going to like the answer, but the OIG doesn't care if you've got 1 employee or 1 million. The law applies the same, or the enforcement of the law applies the same. Now, they do want to know what is within reason, because that is, not a burden they're trying to put on there. The problem with what is within reason is this is public record. The OIG website, if you do nothing else but that, you will still miss things. But if you did nothing else, then that's free. And you can search 1 at a time, up to 5 at a time, or you can download the database and conduct it yourself. So they don't see this as a burden. Now, your earlier point that this is not a requirement but is best practice is very well taken. As I want to be very clear, it is not required that you search at all, nor can you be fined for not searching for exclusions. But the OIG will, does, and can enforce exclusions. And if they find it or it's reported to them, and typically, let me tell you how things come to them proactively. So what happens, believe it or not, when a nurse or practitioner leaves one organization and then moves to another state and enrolls in Medicare or Medicaid as an approved provider, they have to disclose where they worked before on that application. And the first thing the state does that's issuing the new one is check the OIG. And if they see that that employee was excluded, they have to report that to the OIG. So that's how the OIG suddenly magically calls and says, hey, Matt, I see you got 3 excluded employees. How do we know it? We're not telling you the secret, but you owe us X. And that's a lot of the way proactively things occur. Now, I did not mention, but want to make sure you do know that if you do an exclusion search or monitoring and you uncover that you have an excluded provider, what should you do? You should not run and hide under a rock and hope that nobody finds you. You should instead self-disclose to the OIG on their website, and they provide a link on how to do it, because that treble damage that I mentioned to you, whether you can be charged $10,000 for every day or every item and every patient seen, plus 3 times damages, the 3 times damages will be reduced to 1.5. So you have an incentive to do so, but you will not get off the hook for by not reporting or by reporting.
Thanks, Mike. And with that, that brings us to a close this afternoon. I want to say to each of you that joined us today, thanks again for choosing to spend your hour with us. Alan and Jocelyn, thank you so much for being with us and presenting today. We're very happy to have you. Anybody, any questions that we didn't get to, we will be sure to get to after the presentation. I'll say it one more time, you will be receiving a recording of this webinar, a copy of the slides, and your CEU certificate from the Compliance Certification Board. So be on the lookout this afternoon for those.
We do have these webinars occurring on a monthly basis, so check out our website and sign up on the page. I'll be sure that that's linked in there just so you can continue to receive your CEUs. And with that, I will say goodbye on behalf of Provider Trust. Thanks again, and hope you have a great rest of the week.